Hello there. Welcome to Sumit Academy. I do hope that you have subscribed to my channel so that you do not miss out on my previous or future videos. In this video, we shall try to understand the concept of PIL and its impact on Indian society. Public interest litigation or PIL is the use of the law to advance human rights and equality or raise issues of broad public concern. It helps advance the cause of minority or disadvantaged groups or individuals. It is thus the power given to the public by courts through judicial activism. Any individual or a group of people can file a PIL if they prove to the courts that they are not filing the petition for their personal agenda. It can be filed only against the government and not another individual or entity. It is not necessary for the exercise of the court's jurisdiction that the person who is the victim of the violation of his, her or her right should personally approach the court. Such cases may occur when the victim does not have the necessary resources to commence litigation or his freedom to move court has been suppressed or encroached upon. The court can itself also take cognizance of the matter and proceed suo motu, or cases can commence on the petition of any public-spirited individual. Judiciary may step in where it finds the action on the part of the legislature or the executive is illegal or unconstitutional. This initiative of judicial activism has opened new horizons for the poor and the destitute. PILs can be filed in the Supreme Court under Article 32 of the Constitution, in High Court under Article 226 of the Constitution, and in the Court of the Magistrate under Section 133 of the Criminal Procedure Code. The concept of PIL in India is in harmony with the principles enshrined in Article 39A of the Constitution of India to protect and deliver prompt social justice with the help of law. In Western-style jurisprudence, the maxim that regard for public welfare is the highest law forms the bedrock of civil law. The seeds of this concept were sown in India by Kapila Hingorani when in December 1979 she filed a petition regarding the condition of the prisoners detained in the Bihar jail, whose suits were pending in the court. This petition was filed by name of a prisoner, Husnara Khatun. Hence, the petition came to be known as Husnara Khatun versus State of Bihar. In this case, the Supreme Court upheld that the prisoner should get benefit of free legal aid and fast hearing. Because of this case, 40,000 prisoners whose suits were pending in the court were released from jail. India had to wait till 1986 when the then Chief Justice P.N. Bhagwati introduced PIL to the Indian judicial system. Though the original idea was to give marginalized citizens access to justice, but by the mid-1990s, PILs had transformed the legal landscape with a flurry of high-profile cases. From the P.V. Narasimha Rao GMM bribery case, the Jain Hawala controversy, and the Satish Sharma petrol pump scandal, in which PIL petitions were filed by the crusading petitioner H.D. Shourie, to green lawyer M.C. Mehta, who succeeded in removing polluting industries from the vicinity of the Taj Mahal, and the series of cases filed against the Enron project in Maharashtra. PILs have, in many cases, created judicial history. It has, however, proved to be a double-edged sword. By 1997, the trickle had turned into a flood, with over 300 PILs pending before the Supreme Court and another 2,000 in the High Courts, many either of a frivolous nature or the result of political or personal motivation. Genuine causes and cases of public interest have in fact receded to the background, and irresponsible PIL activists all over the country have started to play a major but not a constructive role in the arena of litigation. Many of the PIL activists in the country have found the PIL as a handy tool of harassment. Since frivolous cases could be filed without investment of heavy court fees as required in private civil litigation, and deals could then be negotiated with the victims of stay orders obtained in the so-called PILs. The credibility of the PIL process is also being adversely affected by increasing misuse of PIL by people agitating for private grievance in the garb of public interest and seeking publicity rather than public cause. That may be one side of the PIL coin, but the fact that the courts have acted on PILs to resolve issues that civic authorities and local governments have failed to do is cause enough for celebration of the concept of freedom and democracy. In PIL, vigilant citizens of the country can find an inexpensive legal remedy because there is only a nominal fixed court fee involved in this. Litigants can focus attention on and achieve results pertaining to larger public issues, especially in the fields of human rights, consumer welfare, and environment. In a bid to regulate the abuse of PIL, the apex court itself has framed certain guidelines for the governance, management, and disposal of PILs. The court must be careful to see that the petitioner who approaches it is not acting for personal gain, private profit, or personal political intentions. There may be cases where the PIL may affect the right of persons not before the court, and therefore, in shaping the relief, the court must take into account its impact, ensuring sufficient notice to all interests likely to be affected. It has been pointed out by the Supreme Court that public interest litigation is a weapon which can be used with great care and circumspection, and the judiciary has to be extremely careful to see behind the beautiful veil of public interest and ugly private malice, vested interest, and seeking is not lurking. PIL is a valuable tool for ensuring good governance. It can hold public bodies to account by ensuring that they make appropriate decisions, act fairly and transparently and within the remit of their powers. It can help develop the law by giving judges the opportunity to interpret legislation. It gives vulnerable people a voice by highlighting an important issue and providing a platform for advocating for their rights. It raises awareness of important issues, encouraging public debate and media coverage. For instance, mass petitions were filed in many rape cases as well as murder cases in our country due to the lack of interest on the part of the investigating agencies or even on the part of the government. In conclusion, we can say that PIL is a powerful tool for creating and enforcing rights and is critical to the sustenance of democracy. It upholds the right of the common citizen and gives them a platform for demanding justice and good governance from the government. The machinery governing public interest litigation is undergoing a serious reconstruction or rethinking for possible developments in this field so that the people will get justice and people who abuse it will be punished accordingly. Well, that's all from me in this video. Hope it will be useful for you all. Do like this video and share it with your friends. And do subscribe to my channel now so that you do not miss out on my previous or future videos. Till later then, cheerio.